Counsel, this may be just repeating prior questions, and if so, just repeat your answer. But what about a requirement that the individual show up for probation meetings? Every 2 weeks, you've got to show up, so we make sure that, whatever. Would he still have to do that after the law on which that is based has been declared unconstitutional?
Absolutely, Your Honor, because again, the only effect that the federal judgment has is forward-looking. It is prospective relief. It prohibits the enforcement of the ordinance against him on a forward-looking basis. It does not reach back and affect on a backward basis. Isn't the
requirement of probation just doing that, just continuing the consequences that were imposed from his prior conviction?
Perhaps, Your Honor, but again, Mr. Olivier is not challenging any aspect of that aspect of his probation, which, as a record matter, had already passed by the time the district judge ruled in his favor. But again, in a situation like ours, Mr. Olivier has not and could not challenge any attendant effects of his conviction. Just like in Woolley v. Maynard, the Maynard's driving privilege, they had lost some driving privileges, and those were not affected by the forward-looking relief in that case that simply said you cannot enforce this law on a forward-looking basis to these individuals.
So what would happen if someone else challenged this law on a prospective basis and won? And as the Chief is positing, Mr. Olivier has this obligation to continue checking in on probation.
So, Justice Barrett, we think that hypothetical actually underscores the perversity or the the way it makes nonsense, right?
Opinion, yeah,
that Judge Oldham highlighted.
Yeah.
Is that that ruling would, I guess, undermine the legal reasoning of Mr. Olivier's sentence, as Justice Alito and I were talking about. It would do the same thing, no different, and yet we would certainly not say.
Would there be some separate step then that someone like Mr. Olivier might take to try to relieve himself of some sort of ongoing collateral consequence or probationary period?
Yes, Justice Barrett, there would be a whole series of steps that someone in Mr. Olivier's position would have to take, and to borrow from this court's language in Skater, it is hardly inevitable that he would obtain any relief down the road at the end of the day. But that would be a multiple-step additional process that Mr. Olivier or someone in his position would have to.
And that is so whether he won the prospective, his quest for prospective relief, or whether someone else did. On the same argument that the law is unconstitutional.
Yes, because of course any judgment as to another plaintiff would not apply to Mr. Olivier. He would still, I think, as this court underscored most recently in CASA, he would have to seek his.
But I mean, he would. I guess what I'm saying is that the process. Are you saying that the process would be the same for him whether he was the one who was victorious in the suit or whether a third party was the one who was victorious in the suit? There
might be some slight differences in terms of state procedure down the line, so I don't want to give a categorical, but essentially for all the ways that matter in this case, yes, it would be. And I see my time. Thank you.